All right, welcome everybody to Legal Tech Week for April 12th, 2024. This is the show where we talk about the top stories in legal tech and innovation from the past week. I'm Bob Ambrogi. I have a blog called Law Sites and a podcast called Law Next. And our panelists this week, as you see before you, are Steve. You want to kick us off with the introductions?
Sure. I'm Steve Embry. I write the blog Tech Law Crossroads, um, all about legal innovation and the like. And we here in Kentucky had lots of excitement this week, losing a coach, gaining a coach, lots of wailing and gnashing of teeth. But I guess we survived. Although some people would say maybe we didn't. I don't know.
And can we is your other news you were just telling me about public, or is that
Oh yeah, yes. I am officially been appointed as co-chair of the ABA Tech Show for this coming year.
all
So
right. All right. So if you want a cushy speaking gig, you know who to hit up right there.
right, it's fine. My first call commiseration maybe with Stephanie when she returns.
All right. And Gene O'Grady. Say hello.
Hi, I'm Gina Grady. I write the Dewey B Strategic blog, and I write a monthly column for Legal Tech Hub, and I write about mostly knowledge, research, and other things that interest me. So,
All right. And Joe Patrice.
Joe Patrice from Bubble Law. I was not here last week physically, but I guess I was here as a background. But I'm glad that I can be here in person this time.
You were here as a background. And Nikki.
Nikki Black. I'm the head of SME and external education at Affinipay with the legal brands, including My Case and LawPay. I write legal tech columns for ABA Journal, Above the Law, and the Daily Record, and I oversee and write the our benchmark and industry reports on the My Case and LawPay side of things.
Yeah,
I
you
need
missed
to
the great
figure out.
background. I think if I kind of like stood over here, then it would look like we're together.
It
On
looked like
Zoom.
we were talking. Yeah, I need to. The makeup people obviously do a great job, but I need to figure out how they can like make my lips not look like they're bright red on a vampire face. I need to like scale that out a bit. Next
I
week.
don't know. It looked a little bit like you had somebody at the mortuary do the makeup or something.
Yeah,
I don't know.
right. Yeah.
God.
So next week we'll see if they do the same thing. I'm supposed to do that next Friday too. So we'll see.
Oh, all right. Well, so was that anywhere near as exciting as being on Legal Tech Week?
No. Obviously not. This is obviously the highlight of the week.
Good answer. All right. Well, let's see. You and Steve and Gene were all not here last week, and I want to kick it off. I mean, Gene, you've got one story that's sort of the actual one piece of actual legal tech news, perhaps this week, regarding the Bloomberg Law acquisition. You want to talk
yeah, I
about
mean,
that?
it's interesting. This week, Bloomberg Law acquired Dashboard Legal, which is a workflow tool, and it actually ties into some of the things you're going to be talking about later. But as I've thought about it, I mean, it does, all of the drafting, connecting, collaboration things that everybody has that's competing in that space. But it's interesting because the thing that I find interesting is that it is in a way a play towards the practical law KM tool place, because years ago Bloomberg's first acquisition was BNA. And BNA, I regard, which was the Bureau of National Affairs, they actually invented the practical guidance workflow space, because they had these things called practice management portfolios, or tax practice portfolios and corporate portfolios. And lawyers love them. And it's sort of interesting that sometimes companies get to they develop something that's going to be very, very important for the future, but they don't know how to position it. And these were sort of invisible until they became digital. And then practical law came out of the UK and really swallowed up the practical guidance space, and everybody's been trying to compete with it, including Bloomberg. So I think in some ways, this is actually this is like a side door into a new space workflow that's going to connect people back into the Bloomberg law system, because right now it's not connected to their practical guidance tools, but it is going to be. And then in the future, the only way to get to those practical guidance tools, the other ones, the pre-existing content of forms and checklists and other things, you're going to have a Bloomberg law subscription. But right now they are selling it totally independently of Bloomberg law. And the other thing I thought was interesting, because I looked at your list of what did you call it, Bob? Failures or things that products that
Momentous legal tech fails or something like that.
Okay, you know what you didn't have on your list that I think actually ties into the Bloomberg thing is what was that called? Firm Central. And I think that might have been the first place I met you, when Thomson Reuters did the launch of Firm Central, and it was going to be a centralized workflow system for smaller law firms. And then later, not to hijack the whole conversation, but I think in some ways this is Bloomberg's step into the managing the entire workflow from inception to delegation of work, and connecting it back into research. And what was interesting too is that I think you just wrote a couple of months ago that Firm Central has disappeared. That got shut down after many years. And I actually thought it was a great idea.
Yeah, but I did mention LexisNexis Firm Manager, which was LexisNexis version.
Yeah.
I didn't do Firm Central. Well, actually, there's two reasons I didn't do Firm Central. We could talk about this list later, but one was I actually wrote this article before Firm Central closed, and I forgot about it. Firm Central just closed a couple months ago, closed down. But you give Firm Central points for like lasting this long. It had a decent run. I don't know whoever actually used it. And I think Thomson Reuters really just used it as kind of a loss leader to get get smaller firm lawyers into Westlaw, because they would like throw Firm Central in as a freebie if they subscribe to Westlaw or something like that.
But then for a couple of years, Westlaw was promoting to large law something called Project X. And I don't know if it ever got a name, but that was around for, I think, only like a year or two. They actually
That was what Elon Musk worked for Westlaw, right? That was
what? No, but that was another, Thomson Reuters ended up acquiring HiQ to address the issue.
Yeah.
So I don't know. I think that Westlaw has been in that area, and I don't know how well they've done in it. So, but going back to the Bloomberg thing, one of the things I actually thought was really interesting about this was that they sort of leapfrogged over the generative AI product launch. They say they're working on something, but I can't help but wonder if they have just decided there's too much uncertainty in the marketplace, and it's just easier to launch something that doesn't involve generative AI, that has some practical application for how lawyers actually work. Because actually inside of law firms, especially large law, there's a lot of confusion about whether lawyers can use generative AI for specific clients, and how do you keep them from using it how do you allow them to use it for this client but not for that client? And then there's the whole thing of judges making their own decisions about what you can use or not use. So I think I give Bloomberg a lot of credit for not rushing out a generative AI product and going in a completely new direction that's sort of like counter. It's sort of, I don't know, what would you call it? It's like it's against the trend that's actually happening now, where everybody's scrambling towards generative AI.
Yeah, it was an interesting move. I knew them they were in Startup Alley in 2022, I think it was a couple of years ago, and they were actually the second place winner that year. And Matt Rotenberg, the CEO of Dashboard Legal, was kind of upset because they literally came in second by one vote. and he kind of felt like, the voting, how the voting takes place at ABA Tech Show is basically on an app, and there's always some worry that people are going to get their friends in there voting, or maybe people who aren't actually at Tech Show or something like that, which is kind of, I guess, okay, really. But Matt was so upset about the fact that he lost by one vote. But so I'm glad to see them. I'm glad to see them having a good landing. It's a good product, and yeah, I think Gene, I think you really hit it on the head. I mean, they're really trying to expand beyond research into workflow. And the other thing they talked about when I talked to them, they put a lot of emphasis on the contract drafting platform they had launched last year, um, and try and integrate with that as well, as sort of this whole workflow process, but definitely bringing in the practical law parts of it, and so we'll see. Interesting.
The other thing I thought was interesting that came out when I was talking to them was that Matt had been on a technology committee at his large law firms. And I think that actually gives them sort of an advantage, because knowing what the process is, knowing what you have to prove, knowing what's worth highlighting. I mean, I think that's actually, you can tell a lot of technology salespeople don't actually understand the mechanics of procurement inside of law firms. So he actually has that advantage.
Right. Yeah, that's really true.
Yeah, all right. And it's funny how we give companies kudos when they do something that's not AI.
I don't even know how to respond. I'm so used to
right, like
just like
yeah. So maybe he's talking about something that is AI. Joe, since you had a couple of AI related posts this week, but one has to do a judge who's all fully ready to embrace AI, right?
Yeah,
there you go.
so
Okay.
yeah, a judge ready to embrace AI, which normally is the sort of thing that we would be excited that somebody's so forward thinking. This is the opposite of that story. At a Federalist Society event recently, John Bush, who's a judge on the Sixth Circuit, he got on the Sixth Circuit. His credentials for that job was that he ran an anti-gay blog, which I didn't know that was the sort of thing that can get people on the bench. I write a blog. I feel like somebody could put me up there too. Anyway, the point is,
Yeah.
he gave this speech to the folks at the FedSoc about the promise of AI being that for originalists, we now don't have to spend all this time going through history and finding these like little snippets out of context from some pamphleteer in Connecticut in 1750 that uses one word that we're going to hang the entire Constitution on. AI will be able to just like crunch everything together and spit out a generative answer for us. It was a wild thing to say, because basically his position was, instead of us making up history, we'll let the computer make it up for us. It spoke to a lot of the concerns that we have about it, that basically the prompt engineering was terrifying, that he was talking about, basically saying, hey, look through all this stuff and tell me why, bear arms means XYZ, and it would spit that out. That seems like the sort of thing where even in a world of fixed hallucinations, it would do that sort of thing. Yeah?
Can I point out one thing, that
Yeah.
Thomson Reuters actually has a product called Words and Phrases, which was created by Westlaw, and that actually does trace the history of words, of legal terminology. So you don't need generative AI.
Well, you don't need, but the problem is that just traces legal terms, and those tend to have a liberal bias, as we've learned. A good example being the Heller case. If you read that case, the dissent that Stevens writes goes in depth as to the legal history of these words, and the counter was, we found some newspaper article from 1850 that suggests something else. They are really into picking and choosing weird usage cases from all over the place and stringing together a narrative based on that. That's what a lot of those clerks do in these originalist chambers. And what Bush was saying was AI is going to be great. It's going to take a lot of that time back because now we can just have the AI spit out based on searching whatever. Here's the way in which we can piece these disparate and probably acontextual references together, which is very scary. But it gives it is kind of a logical conclusion of somebody who thinks along those lines. And it's the whole body of legitimate linguistic study, corpus linguistics, that goes through and tries to figure out different ways in which words are used over time. And it tries to track and get some kind of like quantitative and qualitative insights into finding cool meant cold, but now it means cool, like finding those little moments where these words change slightly by by new usages. And as a linguist, that's super interesting. And it talks about broad trends, not about conclusive truth. That's hijacked by these folks into an idea where they can take the databases that these corpus linguists use, and rather than use them to track broad trends or potentially identify cultural or cross-cultural usage and stuff like that, to instead say, find little bits from different places in here and string them together in a narrative that I can present that says, of course, this word can be read to mean what my personal political decision is. Yeah.
Isn't that what every lawyer does?
Well, so ideally, in an ideal world where you aren't looking for original public meaning, but the meaning that people today would have, somebody who breaks the law today would have read the law and been on warning about XYZ interpretation because that's what today is, or looking at legislative history or something like that. These folks eschew that largely because legislative history and current meaning tend not to go their direction. And so what they'll do is a good example, going to the Heller example, despite the fact that there were laws in place that suggested that this is what, and ratification statements and so on that suggested this is what the framers thought they were doing with the Second Amendment. The Scalia opinion is grabbing stuff like, we found there's a newspaper article from 1810 that has the word bear, and it means this here. So that suggests to us that clearly that's not. It's cherry picking. It's almost always non-legal in the sources that they're trying to mine. Lots of standard dictionaries, lots of newspaper articles, lots of pamphleteers, lots of political speeches not on the floor by elected officials, but campaigning. And they utilize that to try to build this sort of narrative. And it seems largely disingenuous today when humans are picking and choosing things from all over. But what Bush is suggesting is that the future of AI as they see it is generative AI as they see it is a way to shove all that data into it and then tell it to go through that data and give them what they prompt engineered want. And they want it to say, find stuff that supports X, and it will pluck it from everywhere.
That's sort of the problem and fallacy in that whole concept. They want to say that we want to get to the meaning that was with the framers' intent when they wrote it. That's not really what they want to get to. They want to find support for their interpretation of what they want the law to be. It's just another way to abuse the whole concept, it seems to me.
We need to get Justice Breyer in here to talk about his new book.
Yeah.
Where he attacks that whole. But the corpus linguistics thing is kind of interesting. I wrote about it a couple of times at BYU, where they've got a really cool database. They have different collections of different kind of texts from historical and contemporary texts where you can do the analysis. Usually what you end up finding out is it's just not very black and white one way or the other in terms of the meanings of terms and how they've evolved. Although it is sometimes funny to see how some words just like never showed up at all or until recently and that sort of thing. was a link to an article I did about it a few years ago about the BYU one. But it's, I mean, all of which, I mean, corpus linguistics aside and AI aside, it does just come down to pursuing a political agenda of being able to try and find language that supports what you're trying to do, and not taking. I mean, you make the point in your piece, Joe, about it just doesn't take into account the fact that language and linguistics are living things and evolve over time, and the law has to evolve with it.
And like real linguists, when they engage in this practice, they aren't, because they're real linguists, they aren't trying to say, we've done this study and therefore this word means X. They're trying to say, look, it does evolve, and look at these fun ways in which it evolves. Like they're celebrating the way in which it is fluid, and to pervert that field of study into, we're going to utilize this to fix meaning, is just so bizarre. Anyway. That's beyond the AI part of it, I suppose.
All right. Well, I'm going around to the panelists who weren't here last week. So Steve, that leaves you, and then we'll get to Nikki. But what do you got this week?
Well, I noticed this survey that Axiom, along with Wakefield Research, did of general counsel. They did it, I think, in January and February, and they basically sent an online survey to, I don't know how many, but they had 300 responses from GCs of what they described as both small, medium, and large businesses. And, it pretty much confirmed in many respects what we'd seen before. I think Everlaw and the ACC did a study before that kind of showed that most general counsel are overstressed, don't have enough resources, their budgets are being cut. They're suffering from attrition, and every time somebody leaves, it's more work for the people who stay, who then decide to leave because they're tired of being overworked. And that didn't what really catch my eye. But the thing that caught my eye is they were asking the GCs about their relationship with and fondness of outside counsel. And 100%, according to the Axiom, 100% of the GCs said that they were not particularly well. I think the way they actually put it is they experienced challenges that caused them to regret engaging their lawyers, which as Molly McDonough, who used to be on the show regularly, pointed out on LinkedIn, really have to get the context of the question to see what they were really saying. But I mean, it's no secret that I think general counsel are not particularly happy with outside lawyers for a whole lot of reasons, and many of the reasons that they cited in the report were pretty well known. Outside lawyers don't give practical advice, but give conceptual advice. For example, that they don't understand how business works and the goal and motive of businesses. They don't communicate well, all the kinds of things we've heard. But what struck me about all this was, we now have this growing group of overworked general counsel who appear to be almost desperate and trying to figure out a way to do their jobs with less and less resources. At the same time, a high level of dissatisfaction with their outside lawyers, which, typically when that happens, most people look for other ways to get their work done. And the Axiom report was saying, well, one way it could be really good, and we think would really be a good solution, was for the in-house counsel. Yeah, hire. Basically, that's what they said. But the other thing that it made me think about was another potential solution is the greater use of technology and AI, generative AI tools by in-house counsel that would enable them to do some of the more standardized work, at least, that sometimes they have to refer to outside counsel. And just anecdotally, I've talked to several inside counsel, and that's exactly what they say, that they're now using these tools to do like NDA agreements or things like that is before they might refer to outside lawyers. And so it just sort of struck me that this may be the linchpin for finally forcing outside lawyers to A, use more of these tools, and B, be a little bit more interested in serving their clients and addressing their clients' pain points. I mean, and every general counsel says, you know, I face challenges in working with my outside lawyers. It makes you think, well, most of these outside counsel must be thinking, well, you know, I don't have to give good service because nobody in my profession gives good service, so I can get away with it kind of attitude, which, you know, I can't imagine is the case of any of them. But anyway, the whole report just kind of struck me as interesting. And yes, you know, I of course appreciate that anytime you have one of these surveys, you sort of have to look at it with a grain of salt as to what's the product the surveyor is selling. But there's been enough confirmation of these kind of numbers out there to make me think that there is certainly some validity to the dissatisfaction and desperate nature of desperation feelings of in-house counsel.
You know, it's that in a way links back to Gene's story that we were talking about, the Bloomberg Dashboard Legal, because one of the interesting things that they're doing, I mean, Dashboard Legal was a product designed for law firms, but they're really going to be trying to market it heavily to corporate legal departments on the premise that corporate legal departments are these days much more like law firms and becoming more and more so every day, and yet corporate general counsel often lack the tools that their counterparts in private firms have to manage workflows and manage staff. And one of the features that Dashboard Legal has is this ability to try and give managing partners sort of a high level view of all the work that's going on within a firm, and you know, resource allocation and what lawyers are handling what matters, and that sort of thing. You know, the idea is that can Joe Brita at Bloomberg Law believes that can apply just as effectively to in-house legal departments and helping them to manage their own staff and workloads, and maybe need those outside firms a little less if they do that.
Yeah, or
It
certainly
also,
it could lead them to say, look, this works for us, outside lawyers. Why aren't you doing this too? I mean, and I've always been pretty firmly of the view that unless and until the in-house lawyers start insisting on certain things from their outside lawyers, they're not going to do it. They just won't do it. I mean, why would you? You're making plenty of money the old way, so why do it? But you know, when I was practicing law, if a client said, "Do it this way," most of the time you did it that way. Might take you a little while, it might drag your feet a little bit, but sooner or later you did it. So, sorry, Gene, I didn't mean to interrupt you.
no,
I
that's
apologize.
exactly what I was going to say. I can't tell you how many products are bought because a client says, you need to have this. I'm using it. I expect you to use it. We've seen that.
Right.
So I think that is, you're right. I do think that is part of Bloomberg's strategy, is to like force the hand, you know, go to the clients first.
So
Well-
I could all give a real round of thankfulness to our overworked in-house counsel for helping to change the world. Thanks, guys.
Well, it's timely because I'm
Keep at
researching
it.
for my ADA journal article this month. I'm going to write about sort of matter management and collaboration software for corporate legal departments. And there's not a ton out there, I found. Like, there's lots of contract analytics and contract review software, which is one function of what they do. But in terms of, you know, kind of like the my case for in-house counsel, right? Like something that helps them understand their workflows, take in intakes, manage outside counsel, know where the different matters are in terms of how the contract's moving through. So there's definitely software out there that does that, but it seems to oftentimes be targeted more towards really large companies with large, almost like mini firms running within them, or actual firms running within them almost. So it's interesting, but there are some sort of upstart products that have been around for a couple of years too. So I'm planning to write about it, and I sort of this dovetails nicely with that. So keep an eye out for my article if you happen to be in-house counsel looking for software.
There
I'll
are two
just
products
point
they're using to manage their matters and workflows, and they're called Outlook and Excel.
Right? Yeah.
Waiting for Dennis to comment on that. All right. Well, speaking of reports and surveys and studies, Nikki, you've got one you've talked about before, but here's another installment of it.
Yeah, so I wrote I finally got around to reading the ABA Journal's Profile of the Profession, or the ABA's report, Profile of the Profession from the end of last year, the 2023 report. And I always like to kind of either write blog posts or articles about some of that data. So I did a two-part daily record series on it. And the article that I'm going to talk about now is part 2, and it focused on demographic data and technology use data. So, and the demographic data I thought was interesting because the rate of change is just so slow. I remember when I graduated from college, one of my parents' friends gave me a book about women in law, and then had all this data about how, you know, women were not in leadership positions, but there are more and more women going to law schools. And I remember thinking, yeah, I'm entering law school now, and this is all going to change. And you know, how little did I know? I had my rose-colored glasses on. According to the report, I mean, we all know that there have been at least 50% for the last decade. 50% of the law students have been women. I think it's actually more than 50% at this point. But according to the report, there are a little over 1.3 million active lawyers in the United States last year, which was a 5% increase over the past decade. So our numbers have not grown very quickly. A substantial number of those lawyers, almost a third, were from 2 states, California and New York, and only 39% of them were women, up from 24% in 2013. The median age was 46 years. But, you know, since women have been graduating, at least for the past decade, if not a little more than that, with more than 50% of women as law school graduates, you would think that there would be more women attorneys at this point. And the other thing that I thought was, so I mean, that's unfortunate. And then during that same time frame of the last decade, the percentage of lawyers of color nearly doubled from 11% to 21%. So it's nice that it doubled, but those are still, well, at least it's moving a lot faster than the statistics relating to women alone. And then the makeup of judges, I mean, this is where it really, you know, you can have all sorts of women and people of color filling up the entry-level ranks of the legal profession. But when it comes to sitting judges, they're predominantly male, 68% and white, 76%. In the state courts, only 20% of the justices were people of color, compared to 40% of the general population, and 58% were men, compared to 50% of the general population. And that was sitting federal judges were 68% male and 76% white. The first set of data points I had mentioned. And then, so that was the data on demographics. And the demographic data, quite honestly, depressed me. So I was happy to write more about the technology data, because at least I feel like there's more progress happening there, surprisingly, than there is in terms of gender and people of color moving through the ranks of our profession. So women and people of color. And so there are a couple notable technology data points that I highlighted in the article. Not surprisingly, lawyers rarely use Alexa and that type of smart assistants like that. Only 9% and only 3% do that regularly. And only 8% of lawyers shared they had a virtual law practice. That number surprised me a little bit. I would have thought it would be a little bit higher than that. Social media usage, which was once frowned upon, especially when I started writing and talking about this in 2007 or so. And when mine and Carolyn's book, Social Media for Lawyers, came out in 2010, still not a lot of progress at that point. But right now, 89% of law firms now have a social media presence. LinkedIn was the most popular network, followed by Facebook. And Martindale's hanging in there at 37%, which actually surprised me in terms of a social network. And then with individual usage, 82% of lawyers interact on social media platforms, which makes me feel like all those years of shouting into the ether have paid off, and also just society moving along and social media becoming commonplace. And again,
They
LinkedIn,
got on social media because they heard you on social media talking about it.
or they read one of my print articles. That's probably more
Okay.
like it. And then the other data points that I thought were interesting was 56% of lawyers are using laptops now. That's more than half, and that's pretty impressive because I've been tracking this for years, and it used to be 20%, 30%. So 56% is definitely probably partly due to the pandemic. Windows was the preferred
What's the
operating.
typewriter percentage?
83% use Windows. And then the only other interesting data point that I'll highlight is 80% of lawyers use iPhones. So I thought that was also interesting. So they like their Apple phones and mobile devices, but they like their PCs rather than Macs. So I thought there's interesting data. I have a lot of interesting data in the article, if I may say so myself, and the report itself has a ton of interesting data. It always does. It's a great place to kind of track how our profession is and is not changing over time.
Yeah, I think correct me if I'm wrong. I think part of that, when they do that report on the profession, they're extracting data from several different reports that they've done, including like the Legal Technology Resource Center study that they do every year on tech.
Yeah.
And I've always, I mean, I've always thought that LTRC study, I don't, maybe they have in the last couple of years. I haven't really looked that carefully at it. Needed some major revisions. I mean, they were still asking a lot of questions about choices of products and whatever, where they just didn't reflect kind of the current landscape of products out there or what people were doing. But like, I don't know, it's interesting. Like, it's surprising to me that it would say like 88% are on social media. I mean, it's hard to believe that 12% of law firms aren't at least on LinkedIn. It seems like everybody's on LinkedIn. Hard to imagine that it's that high of a percentage of lawyers who aren't on LinkedIn. But I guess that's
Well,
possible.
they could be a lot of maybe solo kind of law firms or lawyers or small firms or something. I don't know.
Yeah.
Certainly, most firms of any size would at least be on LinkedIn.
Yeah. I mean, it's extremely rare to look up any lawyer these days and not find a LinkedIn profile. They may not keep it up or maintain it, but generally they're at least on there.
Well, you know what?
That's interesting.
I have a high school reunion coming up, and there's a number of people that went on to become attorneys. And I tried to look them up. And surprisingly, I think one of them, of the 4 or 5 of them, were on LinkedIn. So I think it kind of depends on the type of attorney that they are. I think a lot of criminal defense lawyers don't really think it's useful. Certainly most of my criminal defense colleagues, I would say here in Rochester as well, just don't have LinkedIn profiles. So I think it partly depends on the practice area and the size firm for sure, and how you're trying to go about bringing business into your practice. Some firms don't need that. It's just all word of mouth, and that works great for them.
Yeah. Yeah. All right. So I did a story this week on what I call the 5 most momentous legal tech fails. I was really, what's actually funny about this story is I actually wrote it a while ago, and I wrote it for somebody, a different publication that asked me to write it. I'm not going to name them. And then after I wrote it, they said, I don't think our advertisers are going to like this. And therefore, we're not going to run it. So I didn't. So, but then I was thought, oh, I'll put it on my blog, and I kind of forgot about it, and I actually came across it last week. I said, oh, okay, I'll put it up. And it's been kind of interesting to see. I put it on LinkedIn, kind of asked people what else they would have suggested. I mean, my sort of top pick was Atrium, which I think was kind of the biggest legal tech implosion to come along ever, really. In part, a lot of people said, well, if you're going to say Atrium, well, why not also talk about ClearSpire, which had preceded Atrium and was kind of very much the same thing. Well, very much the same. Atrium was basically a carbon copy of ClearSpire in a lot of ways. But the difference was that Atrium was just so full of itself when they launched. I mean, they were just promising the world, and they were going to revolutionize the legal profession. And they had this Silicon Valley entrepreneur who knew nothing about the legal profession except they'd had hired lawyers a couple times, and decided he was going to shake things up and show everybody how to do it. And it imploded. You know, it was a massive failure. And not that it was a bad idea. And you know, I think part of the problem for Atrium was always the whole regulatory structure. And I mean, Atrium did what ClearSpire did, was set up these two different businesses, one to practice law and one to do all the kind of back end tech support and you know business support and all of that. And I mean, the only reason they had to structure it that way is because law firms can't have, you know, non-lawyers can't have an ownership in a law firm. So it makes for a really awkward structure. And you know, I think that was really ultimately the problem with why why it ended up closing. But
One thing along those lines, what I thought was interesting about both that particular company and some of the other ones that you referenced, and then a few that I can think of, the regulatory structure and the ethics requirements that lawyers have in place and that they have to answer, you know, comply with, impacted a bunch of these different business plans. They caused a lot of them to fail. And part of it is sort of this idea that people are coming in thinking they can either aren't aware of them or can ignore them or somehow operate in spite of them, even though it seems like they might apply. And that often seems to have been the downfall in a lot of these, I thought.
yeah,
Yes,
yeah,
that's a good point. You know, you guys may remember back when in January, I went to the Consumer Electronics Show, and that guy had the gallery of flops, and he had all of these things blown up on the wall. So I'm sitting here now thinking about ABA Tech Show, Bob, and I can just envision you having this booth with your gallery of flops, pictures, full color glossies. It'll be great.
sign your company up to join the gallery right now.
Yeah, right. But I think you may the point that the guy that put that on was making, to your point, Nikki. I mean, he was saying a lot of these failures are simply due to not understanding the business that you're going into and not doing kind of the the vetting of the situation and the business and the product that you're going to get, and not understanding that, you know, it's either too late or it's before its time or all these things. And I think there's kind of a common thread through all of these, except for Quick Legal, which maybe a different situation. So the company that Bob single-handedly did in.
Yeah. And you know, I see Andrew, we have Andrew Aruda in the chat here today, and of course I've got Ross on the list, and now I feel bad for having them on the list. I didn't know Andrew was going to be here today, but Ross, you know, Ross didn't fail or close because of its own doing. It closed because it got sued by a behemoth with a whole lot of money to fight a major litigation. And as we all know, that litigation continues, even if Ross doesn't. Andrew said we're not dead, but I mean, for all intents and purposes, it is. I mean, the corporate entity still lives on, but you can't go subscribe to Ross today and use the product. And you know, obviously, Ross deserves a lot of credit for foreseeing the role of AI in legal research and some of the promise and potential of AI. And you know, a lot of what Ross was working on way back when, in terms of being able to go in and ask a question and get an answer, is what we now see Westlaw doing and LexisNexis doing and VLEX doing. So, you know, it wasn't a bad idea. It was just perhaps also a timing issue as well. But sometimes companies are before their time. But another one somebody mentioned, a lot of people mentioned on LinkedIn that I didn't have on here that I probably should have is Rain in Court. Although, I mean, again, that's kind of still hanging on by a thread, I guess. I'm not quite sure what the status of that is right now. But again, Rain in Court is another one where I actually thought it was a good idea. I mean, I thought the idea of providing this sort of, you know, sort of sandbox environment, secure kind of sandbox environment where law firms could test out cloud-based products that they couldn't test in their own environments and didn't want to invest in deploying in some way, made a lot of sense, and was a way for helping to ease, especially some of the larger, more security conscious firms, into the cloud era. But apparently the firms didn't think so, I guess, because it just never got the traction. Any others that I'm missing on the list?
Well,
I
I
heard
already
somebody
mentioned
mention
Firm
is Tally.
Central.
Anybody remember
Yeah.
Tally? Yeah, your firm.
Oh, well, I was surprised you had Gavalytics on the list.
Yeah,
I mean, it was a surprise in that it was a great little product, but
yeah.
I mean, I guess their lunch just got by eaten once Lexis and Westlaw got into the analytics business. I mean, they were really, I mean, they did a number of things faster than everybody else. And I think they really put state court analytics data on the map, but then they were overtaken. So I don't
Yeah,
know.
and I didn't mean any of this necessarily to mean that they were bad products, or I
Yeah.
mean, I thought Gavalytics was a good product, and I mean, their challenge was the difficulty of expanding state by state and getting these analytics. It's still a
Right.
challenge. I mean, others
Right.
who are out there in this space now are still dealing with that challenge. It's really hard because every state court system has different sets of data and different availability for that data, and some of them still don't even have all of their data online. So it's hugely challenging. But the other thing with Gavalytics was the sort of suddenness of it. I mean, I don't know if you remember, but it was kind of like,
Yes, like Monday morning, a press release went
yeah,
out.
like Rick announced it like on a Monday morning or something, and even the staff hadn't been aware this was coming. It was just like, like we read about your local restaurant, locking the door on a Sunday night and telling the help not to come in the next day. I mean, it kind of had that air to it.
The other thing I think of is, oh my God, Ravel Law. It got bought, but it got bought because they ran out of runway. And I just thought, again, they had a great idea. They had imagined legal research very differently than everybody else. They were using visualization in a very unique, and I just felt like they were another company that deserved to stay alive, but the market just couldn't sustain them. And I sort of, again, I always see small companies coming along and pushing large companies into doing things they should have started doing long ago,
Yeah. Well, it was interesting because we were talking recently about the Case Law Access Project, which just kind of came out of the commercial restrictions. And I just had Daniel Lewis, the founder of Ravel, on my podcast with the Case Law Access people, talking about that whole history. Because Ravel Law was the one, they were a startup and they couldn't get the cases anywhere, and they basically came up with that idea of having Harvard scan, their entire library of print case law, so that they could create this digital database of all the case law of the US. And they went to their investors out there in Silicon Valley and said, we want to give money to Harvard to scan thousands and thousands of case law texts. And the investors were like, go for it.
Yeah.
That surprised me.
Two companies that I think of both encountered the same problem. And they had different trajectories. And they both sort of had a long run, but ended up with the same end result, are Avo and Total Attorneys. Like, they both tried to create these platforms that competed with attorneys in a lot of ways. Ultimately, that's what they ended up doing. And if you're going to compete with anybody, you probably don't want to compete with the people that can litigate and sue you, because you're going to piss them off. And it kind of reminds me of years ago when I was with the public defenders, and I learned that in New York, if you're a lawyer, you can become a notary without taking the test. And I said to one of my colleagues, well, that's weird. Why do you think? He's like, I don't know, we make the laws. I'm like, good point. Like, some lawyers are like, hey, we should be able to do this without taking the test. So I feel like it's the same thing where you flip it on its head. Like, if you're going to create a product that's going to start competing with lawyers and possibly putting some of them out of business, you better tread carefully, and also ensure that everything that you're doing does not violate or even potentially violate any ethics rules. Because if it does, one way or another, you're going to get some lawyers that are going to sue you, or that are going to talk to their friends on the ethics boards, and they're going to come after you. And that's essentially what both of them, those two companies, well, Avo didn't go out of business, but when some of those ethics complaints ethics opinions came down at the very tail end before they got bought out, they pretty much decimated a large part of that platform. And it didn't look like there was any return from that. And what happened with Total Attorneys was initially some lawyer got really mad and sued them in multiple jurisdictions. He was a bankruptcy lawyer who thought he was losing business because of them. He didn't think that what they were doing was ethical. And between his lawsuits, and he convinced all these other jurisdictions ethics committees to bring he filed complaints. And so they all addressed it and said it wasn't a legitimate way to go about it. And so that essentially put them out of business. So I think that that's something that people have to be really careful about when they come in and try to compete with lawyers. Lawyers don't like that. And you got to make sure that you've got all your I's dotted and your T's crossed if you're going to do that.
Not to mention the bar associations, who are more than happy to contribute to the cause of driving those companies out of business for the same reasons.
Yeah, I mean, Avvo was attacked early on for its lawyer rating thing, and I mean, I think to this day I'm still a perfect 10 on Avvo, even though I don't even really practice much anymore. But they were doing some really innovative stuff in terms of trying to make legal services affordably available to people, and it was a constant battle for Mark Britton against bar associations and regulators and others who were always trying to shut him down. I still don't know though why he sold it out to National Brands or whatever it's called, the
Internet
big
Brands.
like internet SEO company, Internet Brands.
Internet brands. Yeah, I have a different
I mean-
perspective on what those platforms, both of them did. I don't think Avvo was, everyone says they're trying to bridge, the access to justice gap, but they're trying to make money. I don't buy it when really what they're doing is profiting. I don't think that what they're doing is, most of the time, that's skin that people put on, tools that are going to compete with lawyers, and but at the end of the day, they're making money off of those tools. I don't think that that's, I question that that's what, I would describe it very differently, what they did.
Well, but they had set up this service for people to call in for, what is it, $49 and speak to a lawyer and get legal help, and I forget, they had a whole bunch of really kind of low cost, innovative ways of connecting people to lawyers at a very low and affordable cost, and nobody else was doing that at that time. And yeah, of course they were in it for money. It was a profit making company, but.
But that's what all of what happens in when you have people outside of the law looking at the law as this potential to create platformize or disrupt the law. That's how they all say you're going to do it. Go around the lawyers, provide these online legal services. So it's like Uber, the equivalent of Ubering for a lawyer. You open up an app and you got the lawyer there, and they all think that they can do this to the practice of law, to the detriment of lawyers' businesses, and also to make money and take it away from the attorneys. And I feel like that it's just this, it's a lot of talk and it doesn't actually work. Like it wasn't actually working. I don't think it was actually serving the consumer. I don't think. But
well, Andrew's point in the chat is right. Like lawyers were making money too, and there is something to be said for bar associations, which I do believe licensing has a value. But that said, are a monopolizing entity, right? It is an attempt to skew the market to prevent new entrants. What those services tried to do was to try to basically low bono things where you could talk to actual lawyers, but at a lower rate because they streamlined it in certain ways. They were making money, but they were doing it by trying to reduce the overhead involved. But the flip side of it is to say people should pay way more money to people in the usual lawyer practice. And that's not much better. Like all these people are trying to make money. The right answer, of course, is you just type it into Chat GPT, take whatever it spits out, put that in your brief, and you'll be fine. That is sarcasm, by the way. Just saying that since I think there's a transcript to run it.
No, but the other fact is that in fact a lot of these matters that do get handled by those low bono, as you say, programs are ones that aren't going to end up going to a lawyer. It's not like they're taking money out of the pocket of a lawyer because those people are never going to go to a lawyer. If they can get
Right.
people who are paying $59 for 15 minutes of consultation with a lawyer through Avo are not people who would have gone and spent $5,000 to put down a retainer to talk to a lawyer about some matter that they have. It's
But I
just not
still
the
think
same
that's
thing.
LSC. And I still
what?
maintain that's what LSC does. That's what legal aid
Oh.
does. That stuff needs to get funded. You don't need to privatize this access to justice gap, because every time you privatize anything and you have capitalism, what ends up happening is it never ends up being good for the little person, ever. Like, when
So are
does
you-
this thing turn out?
Nikki,
solves
are
the
you
person?
saying there's enough legal aid lawyers to go around?
No, there's
Right.
not, but that's a way to
What are you
actually get it
saying?
done in a way that is to the good, to the benefit of the people that are seeking lawyers. I don't think that these online platforms where you can, and it's not just Avo, there were, LegalZoom and all these other ones. I personally don't think that they solve most legal problems. They actually create them because there are reasons that you go to a lawyer, and when you create a will,
They were lawyers, though.
Sorry?
But they were connecting people to lawyers. It was still a lawyer at the end of the day that they were connecting people to get this advice. It's that they were doing it through this platform where they were connecting to their own people. Like, it was kind of like a giant referral network, sort of. But it was still a lawyer involved. And I like the low bono thing. I agree completely with the idea that you can't solve the access to justice gap where the access to justice is like really indigent folks. That's not going to be solved by privatizing the system. But unfortunately, we've reached a point where legal services are so expensive that you've got like middle class family of like making 60, 70 grand a year who can't get a lawyer to handle some like disagreement they have with their neighbor. Like, that's that kind of space where getting a lawyer on the line to give you $49 worth of, here's just how this system works, and you otherwise were going to be pro se. That space is the space that legal aid's never going to be able to touch, and private lawyers are priced themselves out of, and that's where that, I think, fits.
Right,
And
not
it's-
all
and
of these
it's not-
people qualify for legal aid. Even
Yeah.
if the money was limitless, but they
Yeah.
don't qualify based on income. And C and B, legal aid just doesn't handle all of these kinds of things, and it can't handle all the little questions that come along that may have nothing to do. Legal aid does housing and family and very specific things, but
And
there's a whole
that's
host
not
of
to
problems with it.
that's not to mention, to Joe's point, it's not always just individuals. I mean, there's a lot of small businesses, startups.
Yeah.
All these
Yeah.
people are in the same boat. They have relatively simple questions. Maybe they're not simple, but they can't afford to retain a lawyer to get to the answer.
Well, and Sarah says, I was just going to say something Sarah says in the chat for the record. Sarah makes a good point that cost is just one of the things that also there are people who just don't even know they have a legal problem. And I think that's also a cost thing. Like, I might call a $49 consultation with some lawyer to just be like, my neighbor did this to me. Is that even a legal thing? And if they tell me yes, then I can go out and do whatever. But I might not, if I had to spend $400 to have that conversation, I may never do it.
But I wasn't very eloquent when I was trying to explain the reason that these types of things sort of offend me. But at the end of the day, I've never found, they had this before online platforms came along. There was when I was in the law firm, there was something you could subscribe to, and it's like an insurance, a legal insurance, and you could take these cases on and handle them on a one-off basis, and it was cheaper for the person who had the insurance to do this. It's the same idea, but it was never in-depth analysis. It was always like a one-off answer that wasn't super complex. It didn't really solve their problem. And I feel like that's what often happened with these online platforms. Like, it didn't actually solve their problem. It just created content for the platform. It created and allowed them to monetize it, so the lawyers felt like this is the only way they were going to get business, because they couldn't compete and they couldn't get SEO, so they had to pay for this platform, and then they would couldn't actually answer the question there, and then they would try to talk to the person offline, and these people could never actually pay for a lawyer. So it was
We were
like
talking about the Q&A thing,
That's-
but Avo had couple of different services that actually connected people to lawyers in private consultations, not public Q&A forums.
But the Q&A is how they make the money from the lawyers. The lawyers had to pay oftentimes to get their stuff promoted or to be heard more. And so lawyers started to feel like not only did they have to have their profiles paid for and promoted in order to show up in search, but also that the only way that they could try and get work is by engaging in this platform, creating content for the platform, and then having these offline consultations that hardly ever resulted in clients that could actually pay them. So it's like taking money from the lawyers because of the structure, but that's what I meant, not like lawyers that were desperate clients.
To your point, Nikki, when I founded the blog, I needed to prepare articles of incorporation. I wasn't a corporate lawyer, so I had no idea. So I went to one of these online providers that I won't say who it was that do things like this. And so they quoted me a price, and I thought, boy, that's kind of high. I went to the Kentucky Bar Association page, and there was a free form sitting right there. So, it's not just that they're charging for it. It's like there's a lack of awareness of what is available that may not cost anything.
Yeah. Well, just when it gets good, we run out of time. We're all heated up.
To be continued.
We can talk more about access to justice in another show because obviously we all have a lot of thoughts about it. But and open law, we can talk about that too. But that has to do it for this week. So anything else anybody want to say before we wrap up, or other than that, otherwise we will be back next week and carry on talking about some of these topics. Hope you all have a great week, and if anybody wants Broadway tickets, ping me.
Bye all.